Welcome to Looking at Legal Stuff. Today we have an interim evidentiary hearing in the divorce of a high-conflict couple where mom is requesting to be made primary parent temporarily until their trial in 4 months due to dad's disturbing and unstable behavior. He doesn't want to get divorced and he's been behaving badly because of that. Not only is mom concerned about dad's harassing and controlling behavior of her, but she is also concerned about a recent incident that involved disciplining the child. What does the judge think about mom's concerns? Let's find out.
All right, next matter on the court's docket. Well, because this was a different session, Barnes County District Court is now in session this July 7, 2026. Time is now 2:11 p.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Barnes County. This matter is venued in Barnes County. The Barnes County courtroom is open and available to the public. The courthouse is open and available to the public. We're live streaming today's event on the Southeast Judicial District's live stream YouTube channel. Matter on the court's docket scheduled for 2 o'clock is Cole v. Cole, 02-2026 DM10. Matter is scheduled for a virtual hearing by reliable electronic means. There's a person connected with the moniker Zoom user. Can that person unmute and identify themselves? Is that Mr. Cole?
Yep.
Okay. We'll get your name changed on the screen. So, court notes for the record, Adam Cole is present by reliable electronic means, together with his attorney, Tracy Lyson, appearing in a separate location by reliable electronic means. Crystal Cole also appears. Jennifer Jensen is listed as attorney of record. However, who is appearing on behalf of Miss Cole, I can't quite see.
This is attorney Tatiana Hackman, Your Honor. I'm another attorney in Jennifer Jensen's office.
All right. I appreciate that. So Miss Jensen remains attorney of record, is that correct?
That is correct, Your Honor. Yes.
All right, thank you. And so we're here for an interim motion hearing. This is a divorce action involving parental rights and responsibilities. Before going on the record, the court has reviewed the notice of motion, motion for interim order, the brief in support of the motion for interim order, declaration of Ms. Cole, and the exhibits, which include record index 18 through 30, the plaintiff's financial statement under Rule 8.2, record index 31, and the exhibit to the financial statement, record index 32. The court notes that there was a supplemental declaration filed on June 30, 2024 from Ms. Cole, record index 37, together with a number of exhibits, inclusive through record index 45. The court reviewed those as well. The court notes that Adam Cole filed a declaration on the same date, record index 47. No 8.2 financial statement has been received from Mr. Cole. And it doesn't appear as though Mr. Cole had an opportunity, or at least didn't respond to the supplemental declaration filed on the same date. No other non-party declarations were received. Ms. Hackman, it is your client's motion. Do you have an opening statement?
Your Honor,
Uh,
before we get to that, can we just take up that supplemental affidavit? I think pursuant to the rules that additional information would be untimely under the rules. The moving parties' declarations must be filed at least 21 days prior to the hearing. And as you've noted, the filing timeline of that was exactly the date that my client's response was due, which was being circulated for signature and filing at the time that we received that late filing. And so there was no opportunity for us to respond to that prior to today's date. I've also not had a chance to talk with my client about the allegations that were made in that. And so I would ask the court to strike that supplemental affidavit and those exhibits as untimely under the rules.
Ms. Hackman.
Thank you, Your Honor. That, as the court has already noted, my client did file her declaration on June 9th originally. That was filed with this court. 7 days prior to the hearing, actually 8 days prior to the hearing on June 30th, my client did file that supplemental declaration outlining additional information that had happened. It was limited to information that had happened between June 9th and June 30th when that interim motion was filed. It was provided within the timeline provided within Rule 8.2. There's been a week for counsel for a defendant and the defendant to speak about it and be able to respond to that. So we don't believe that motion should be, or that declaration or any exhibit should be stricken from the record.
So Ms. Hackman, in Rule 8.2, where does it say that a petitioner can file any supplement?
Your Honor, Rule 8.2 does not specifically delineate that.
And if it does, the respondent is to have at least a week to respond, correct? Or any other time that the court, in fact, it says 14 days, if I recall correctly.
Yeah, there's a couple different provisions within Rule 8.2D. If the respondent raises new issues, then that needs to be filed 14 days prior. If it's responding to just the initial motion and no new issues are raised, then that needs to be filed 7 days prior. My position on this would be that Ms. Cole provided communications between her and Mr. Cole that he was certainly aware of. And the court would be deprived of the opportunity to consider the full circumstances if we limit the evidence to that information that was just provided June 9th and disregard what has happened since then.
So how is it fair to Mr. Cole that on or about the same date that his responses were due, your client files another supplement alleging new issues, including domestic violence, a super factor under the best interest analysis? How is it fair that he doesn't get an opportunity to respond, particularly in light of the fact that July 3 was considered a holiday, there's a weekend in there, and then it really is 2 business days to respond, or a business day and a half to respond? How is that fair? And so if I don't strike it, does that mean that I grant a continuance and then we blow the 30-day window that is also included in Rule 8.2 in terms of a matter of fairness?
Your Honor, to start with that latter question, I don't believe that this is anything that requires a continuance of this matter, and this is something that needs to be heard given the issues.
So how is it fair? So if he doesn't have an opportunity to respond because your client filed something that the rules don't allow, or at least they don't specifically state are allowed, and he doesn't have an opportunity to respond, how is that fair if I don't grant a continuance or strike the pleading?
Your Honor, again, my position on this would be that it's information that both parties were aware of. And
that's not the way the evidence works under Rule 8.2. So how is it fair?
Your Honor, the court, I don't believe it's satisfied with my response here. We don't believe that this hearing should be continued. There are different rules that could be invoked here, and I apologize, I don't have it pulled up at the top of my screen providing that declarations and other evidence can be provided 24 hours prior to a hearing. And so if that were to have been something that was filed, I think we would have been engaged in a different conversation. And Ms. Cole certainly would have welcomed that conversation of should the court take into consideration something that was filed later. However, to be in court today and say we didn't have an opportunity to respond to things that had come up and were within the defendant's control, I think is something that the court should reject that argument, proceed with this hearing, and not strike that declaration and the exhibits from the record.
Ms. Lyson, your thoughts?
Well, my thought is exactly that it has to be stricken under the rules because the rules don't allow for submission of additional evidence beyond that 21-day time period that's outlined pretty clearly in the rule. And the remedy would be if the court intends to consider that. And I do agree that there's some very serious allegations that were made in there. Again, my client should have the opportunity to respond to that. The remedy would be a continuance, and then we are outside that 30 days.
Ms. Lyson, you'd agree that domestic violence as alleged would be a very important factor for the court to consider?
Absolutely, Your Honor, I do. Yep, absolutely.
And you would agree that the remedy is a continuance for unfair surprise?
I would, Your Honor.
And in light of that agreement, does that mean that you waive the 30-day requirement?
We would, Your Honor.
Ms. Hackman, if you want me to consider the matter, why shouldn't I grant a continuance to afford Mr. Cole an opportunity to respond?
Your Honor, if the court is inclined to grant a continuance, given the allegations that are raised here, and if the court wants a response from Mr. Cole that can be handled outside of the scope of cross-examination on those matters, we would request that a hearing be set as soon as possible on this motion. The court has indicated that it's familiar with the issues and the pleadings, and so I believe the court recognizes that these are time-sensitive issues that need to be handled. So if we're sitting here and we're saying that this needs to be continued, then my preference would be that we set a new hearing date at this hearing to delineate and know when that hearing is going to take place within a timely manner. So that would be my position on that issue, Your Honor.
Here's what I'm going to do. I'm going to take a short recess. I'm going to talk with my support specialist to get some dates, and we're going to take care of this matter right now. I am going to continue the case. I'm not going to strike the pleadings. I understand Ms. Lyson's argument. I understand Ms. Hackman's argument, but I think the remedy the Supreme Court has repeatedly said is the appropriate remedy for unfair surprise is a continuance, even though that means that we might be outside that 30-day window. I'm going to give Mr. Cole an opportunity to respond. And so I'm going to take a short recess. I'm going to go off camera and I'm going to have a conversation with Ms. Strom, and we're going to get some dates for the parties and we'll get it back on the calendar. All right, so we are going to take a short recess. We're off the record. All right, Lori, can you hear me?
I can.
Back on the record in Cole v. Cole, 02-2026 DM 10. Parties previously identified are present. Court took a brief recess to address its calendar. The court is also aware of the 30-day timeline that these issues are typically resolved in. By my count, the 30th date is July 9 in 2 days. I'm going to give Mr. Cole an opportunity to respond. Dates I have available: 7/15/2026, 2 p.m. by Zoom. Or 7/16/2025 or 2026 at 2 p.m., although that's less preferable for me than the 15th. Ms. Lyson, does that work for you, the 15th?
The 15th does work, Your Honor.
That
Ms.
works on
Hackman,
our
does
end. Yes.
that work for you?
Yes, Your Honor. Thank you.
All right, so we will reschedule the hearing for the 15th of July, which is a little more than a week. 2 o'clock Central Time by reliable electronic means. Ms. Lyson, how soon do you think you'll have your client's response in?
If we could have until just this Thursday, we could get it done by this Thursday.
All right, so your response will be due Thursday, and if there is any reply to the response, the rule does allow that. If your client raises new issues, I'm going to order that those be filed no later than end of business Monday.
Okay.
Anything else from the parties?
No, Your Honor. Thank you.
No,
All
Your
right.
Honor.
So with that, Barnes County District Court is now in session this July 15, 2026. The time is now 2:03 p.m. My name is Nick Thornton. I'm a District Court Judge for the Southeast Judicial District, which includes Barnes County. On this afternoon's docket, scheduled for 2 o'clock, is an interim motion hearing in Cole v. Cole, file 02-2026 DM10. These are open and public proceedings. The matter is venued in Barnes County. The Barnes County Courthouse and the Barnes County Courtroom are open and available to the public. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. Again, these are open and public proceedings. The court notes that Crystal Cole, plaintiff, is present by reliable electronic means, together with her attorney, Tatiana Hackman. The court notes, is Adam Cole with you, Ms. Lyson?
He is not, Your Honor. I talked to him this morning and confirmed that he was going to be here. I just sent a message to my paralegal and hoping maybe he's having some difficulty connecting or something. And I anticipate he would be here.
There are persons that are present in the courtroom and I can't see who they are. And so I don't know if he's in the physical courtroom.
Doesn't look like it, no.
Okay.
Oh, maybe this is him now.
But the person with the phone number 829, unmute and identify yourself. Will the person with phone number 829 unmute and identify yourself, please? All right, Barnes County District Court is now again back in session this July 15, 2026. Time is now 2:14 p.m. We're back on the record in Cole v. Cole 02-2026 DM10. Attorney Hackman present, Attorney Lyson present, Crystal Cole present, Adam Cole present. We're here for an interim motion hearing. The court has read the interim motion, the briefs in support, and in opposition, the declarations filed, including the supplemental declaration and exhibits filed by Ms. Cole. The court received Mr. Cole's original declaration and supplemental declaration together with a financial statement and pay stub. Ms. Hackman, any other preliminary matters we need to take up before we move forward?
Just as a very brief housekeeping matter, Your Honor, knowing that this matter is streaming and not having appeared in front of Your Honor for this type of proceeding before, does the court have a preference on the references to the child, whether it be through the full name, initials, just saying the child?
Either the child or initials would be my
Okay.
preference.
Okay, thank you, Your Honor. Other than that, I don't have anything.
All right. Ms. Leeson, any other housekeeping matters?
Just from my perspective, Your Honor, I'm wondering how the court prefers to handle it. You know, these interim ones are always a little bit confusing just because the testimony from the parties is what's in the declaration. However, there's been a number of exhibits that have been filed in support of Ms. Cole's motion and as part of her supplemental that are objectionable. And so I don't know if Ms. Hackman intends to offer all of those exhibits now and if I'll have a chance to offer my objections to those. Again, simply because I just have the right to cross-examine. She's not putting on direct for her client.
Well, there's a recent Supreme Court case. I guess recent is relative. It probably was decided last year, discussing the difference between the court's Odyssey record or matters of case record and matters of the evidentiary record.
Mm-hmm.
Rule 8.2 sort of blurs the line because I'm supposed to consider the declarations as evidence. And when a declaration is filed, it doesn't give the other party an opportunity to object. And often those declarations are replete with hearsay and other objectionable materials. And likewise, when exhibits are attached, often those exhibits are replete with hearsay and other objectionable materials. Many family law lawyers just sort of let that slide, and the rules of evidence are sort of loosely applied. I'm of the approach typically that I'm going to give the parties an opportunity to object, and if anything is objectionable and the court rules as such, I have already reviewed everything because the rule presumes that those things are evidence, so I've read them. That being said, if anything is objectionable and the court sustains an objection, the court is going to strike from its consideration and not consider those particular exhibits or statements. And so my preference is for the parties to offer their exhibits and give the other party an opportunity to object. And I should say offer their declarations and exhibits to make it clear that they are part of the evidentiary record, not just matters of case record. So does that answer the question, Ms. Leeson?
It does. Thank you.
All right. Does that answer or at least explain to you, Ms. Hackman, how I intend to proceed?
Yes, Your Honor.
All right. So with that, are there other matters that the court needs to take up preliminarily before we do opening statements?
No, other than I would offer my client's declaration and his supplemental declaration, Your Honor.
All right.
We
And
did
there were
not
some-
file any exhibits to those.
There were exhibits to the financial declarations, right?
Correct.
The pay stub,
Correct.
and you're offering all of that.
All of that, yes.
So in particular, just to be clear, we're talking about from your client, record index 47, 53, 51, and 52.
Sounds accurate.
Ms. Hackman, any objections to
No, Your Honor.
47, 53, 51, 52?
No,
Those
Your
supplements or those declarations and exhibits are received without objection. Ms. Hackman?
I would likewise move to enter my client's declaration found at index number 20, along with the exhibits A through N, into evidence, which are found at 21 to 30 in the index, along with her financial statement and exhibit A, which are found at 31 and 32, along with the supplemental declaration of Crystal Cole dated June 30th, which is found at index number 37, and then the attached exhibits, which are found at index number 38 to 45, Your Honor.
So just to make sure I've got it all, we're talking about financial declaration 3132, and then your declaration or your client's declaration record index 20, and then 21 through 30, 31, 32, 37, 38 through 45 inclusive.
Correct, yes.
Ms. Leeson.
I do have some objections then, Your Honor. In the declaration of Crystal Cole, and that would be index number 20, I would object to the hearsay statements that are contained at paragraphs 7, 10, 15, with the exhibits that were filed as part of that.
So we're going to take these up
Okay.
one document at a time so everyone can be on the same page, and let me pull up that declaration. All right, so record index 20, paragraph 7. There's a whole lot of statements made in that paragraph. So Ms. Leeson, I need you to be a little bit more specific.
Sure. I object to the statements that were allegedly made by the child about statements that my client allegedly made to him. It's hearsay within hearsay, so we'd object to those statements.
Ms. Hackman.
Thank you, Your Honor. Those are included within there, Your Honor, really to, number one, it's an opposing party statements as far as any statements made by Mr. Cole in this matter. Beyond that,
That might cover one part of hearsay within hearsay.
Correct, Your Honor. And moving further upon that, these are being shown in a general matter as far as the effect on the listener, the effect that Crystal had hearing these things. My position would be whether or not these things are true, it's what Crystal believes, and that's the purpose for which they are being offered. And the court being able to hear the evidence and sort through these things, knowing that this isn't a jury trial, can sort through the purpose that those are being used for.
So paragraph 7. During my conversation with WRC, she disclosed to me that Adam told her I do not want to parent her and that I do not love her. That statement is hearsay, and it's also hearsay within hearsay. The court finds an exception to hearsay applies. A statement or declaration by party opponent applies to what would be Adam's comment. The matter was offered to prove the truth of the matter asserted, although not. That's how the court reads that statement. It was not explained or offered in the declaration to be that of effect on listener. The court sustains that objection. That statement is stricken and will not be considered by the court as evidence. Is that the only statement in that paragraph, Ms. Leeson, that you object to?
No, the first sentence, WRC informed me Adam calls me names, tells her I'm a shit, that I am stupid, and that my opinion does not matter. That also same objection, hearsay within hearsay.
Ms. Hackman?
And Your Honor, I would have the same response to that as far as that first level of hearsay and then being used for the effect on the listener. And as far as my client and her intent in seeking this motion after the fact.
That objection I'm going to overrule. I think and for the same reason, the court finds that it is hearsay within hearsay with respect to the first hearsay layer of Adam to WRC. That statement is a statement of party opponent. With respect to the second half of that statement, or the second half of the hearsay or second layer, the court finds that it's not being offered for the truth of the matter, that Miss Cole is a shit, or that she is stupid, or that her opinion does not matter, and that does reflect effect on listener. And so the court overrules that objection. Anything else in paragraph 7?
No, Your Honor.
All right. So then we move on to paragraph 10.
Paragraph 10, she's offering text messages between the child and my client. Again, these are statements made not while presently testifying, offered for the truth of the matter asserted. It is hearsay, and I would object to those statements that are in that declaration. I guess we can get to the actual exhibit itself when we're done with the declaration.
Ms. Hackman?
Your Honor, I would first note that it's an opposing party statement, and the same response is being provided as far as it's not a hearsay purpose. It's not being offered that he is the odd man out or anything of that nature. It's being offered to prove the effect on Crystal when she saw that and what has been going on, and thus her intent in filing this motion.
No, the objectionable statement there is that the child asked him to stop. That's the child's statement. The child's not here to testify.
Ms. Hackman, your response?
Again, Your Honor, my response to this would be it's not being used for the purpose of the child asked him to stop or that he continued to message her. It's being used for the purpose of understanding what has been going on here and the effect on Crystal when she reviewed these.
The court sustains the objection. That portion of the first sentence, or the first sentence, is stricken and will not be considered. Paragraph 10. Any other objectionable statements in paragraph 10? I'm sorry, you cut out there, or at least I didn't hear you.
I'm sorry. No, Your Honor, not in 10.
All right. 15.
15 would be similar. It is text messages that were between my client and the minor child, where the minor child is relaying that, or actually it was a text message between Crystal and the child, where the child is relaying a statement that her father allegedly said to her. That's the objectionable part, as well as that exhibit that goes with it. It's a statement made by the child. She's not presently testifying. It's hearsay within hearsay.
Ms. Hackman.
Your Honor, it's an opposing party statement.
The child?
I'm sorry. Let me clarify. I take that back. This is being used for the purpose of the effect on Crystal, which is the information that was relayed to her as it relates to parenting time, and thus the concerns that she has related to parenting time. I apologize for the misstatement at the beginning, Your Honor, but again, that is our response, that is the purpose this is being used for.
That's the purpose that it's being used for, yet it's being quoted?
Your Honor, this is one of those things I think that the court noted oftentimes comes up in these cases. where information is provided. And I believe the court can give it the weight and use it for the purpose that I just offered, which is the effect on Crystal rather than whether or not that statement is true.
If it's not admissible under the rules of evidence, the evidentiary weight is 0, right?
That is true, Your Honor. Yes.
Objection sustained. I will not consider that statement as evidence. Anything else in the declaration, Ms. Leeson?
No, Your Honor, not in that declaration. With regard to the exhibits that were then offered as part of that declaration, I would object to Exhibit D, which is an audio recording between the child and Crystal, where she's offering the statements that you just sustained the objection about things that her father told her. Again, hearsay within hearsay, and so I would object to that exhibit being received.
Ms. Hackman?
Your Honor, our position on this one would be the child statements in this don't really matter. There's a tone of voice that does matter, and Crystal is offering it for that purpose, as to what the effect on her was after having this conversation. And so we are offering it for that purpose.
But Crystal Cole is going to testify, and she can tell me how she felt, right?
She can. Well, in this type of proceeding, Your Honor, I should take that back a bit. She is going to be cross-examined. She already submitted her declaration. The court is aware of the Rule 8.2 proceedings. And so her opportunity to testify here today is somewhat limited by the rules of evidence. But nonetheless, that would be our position on Exhibit D.
The court already sustained the objection as to the substance. I'm going to sustain the objection to the court receiving D, which is reflected in the record as Record Index 34. Any other objections?
All right. Exhibit E, for the same reason. It's a recording, audio recording between Crystal and the child, again, where she's making statements about things that my client allegedly told to her. It's hearsay within hearsay.
Ms. Hack?
And Your Honor, looking at the declaration in which that was Exhibit E was attached to, Crystal's statement was that the child was upset and visibly distraught from the conversations that Adam had with her. That wasn't being offered for the truth of anything that was said in there. The substance wasn't quoted, nothing like that. It was the effect on Crystal as to recognizing that the child had been upset and distraught, and we're offering it for that reason.
Refresh my recollection where that is in your client's declaration.
Paragraph 7, Your Honor.
So certainly in paragraph 7 of the declaration, Crystal's observations are not hearsay. And they're frankly opinion, layperson opinion. So that isn't objectionable, and the court didn't sustain that objection. So with respect to the substance and what actually was said in this recorded conversation, I think that's the basis for Ms. Leeson's objection. Is that correct, Ms. Leeson?
That is correct, Your Honor.
All right. So with that, Ms. Hackman, what's the purpose and relevance of Exhibit E other than to prove the truth of the matter asserted when your client's declaration already says she was, in her opinion, visibly distraught?
Thank you, Your Honor. It was providing documentation of that upset and distraught behavior that she was noting. That is delineated in her declaration at Exhibit E. Again, noting there are no references to those specific statements or anything like that. that were relayed in Exhibit E.
But Exhibit E contains not only the verbal tone and emotion that the court can discern, but also the substance of what is being said, right?
Correct.
And you're saying you're offering E only for the tone and substance, not the substance.
Correct.
Ms. Leeson?
I think there's a number of statements that are made in there that obviously are objectionable. Not all of them were quoted within the declaration itself, Your Honor. And so I think to receive that would be an error. I mean, it contains a number of statements about things that allegedly my client said to the child, that the child is relaying.
All right. So here's what I'm going to do with respect to Exhibit E. I will tell you that Exhibit E will be received over objection only for the purpose of tone, emotion, and the observation of those things, those non-verbal, non-hearsay, non-declaratory elements, not for its substance and not for the truth of the matter asserted. So with respect to the contents of the speech, I am not considering that at all. That is hearsay. But with respect to the tone, emotion, and the like, the court is going to receive Exhibit E for that limited purpose. That again is Record Index 34. Any other
Yes, Your Honor, sorry.
objections?
Exhibit F would be the statements that were made. Let's see, in paragraph 10, I believe you sustained that objection. It's text messages between the minor child and my client. Again, the child is not here to testify about those statements in that. So I'd object to Exhibit F.
Ms. Hackman.
Your Honor, based off of the court's prior ruling related to these messages and the statement and the declaration related to Exhibit F, I do believe that the court would sustain this objection. And so for that reason, I would state what I already stated, but understanding the court's position on this matter, I'm not going to repeat my prior argument.
Record Index 24 is excluded. That's the text messages in Exhibit F.
The next one would be Exhibit G, and that is a police report that would contain statements from the officer about other, I mean, it's also hearsay within hearsay. It would contain statements that other people told him or her. So for that reason, I would object to the police report, Exhibit G. Similar, Exhibit I is also a police report. She can certainly testify that she contacted police on that date. I think that was the intention of the statements that she's made in the declaration, but to have the police report itself, I do object to those exhibits.
So G is 25 and I is 27.
Correct.
And the objection is
Hearsay.
hearsay. Ms. Hackman.
Thank you, Your Honor. Looking at my client's declaration dated June 9th, in which she provided these are discussed at paragraph 13, being Exhibit G in paragraph 13, Exhibit I in paragraph 17. No statements from the police statements were introduced. It was merely relaying that my client had contacted law enforcement. She's not introducing these to have any record of what happened as far as law enforcement goes, but is providing documentation of the fact that there was law enforcement involvement here, which I do believe is a non-hearsay purpose within the rule.
Say that, I want to make sure I understand your response, Ms. Hackman. You're saying it's not hearsay, even though Sergeant Knight isn't here to testify, and it's clearly Sergeant Knight's report.
We're
But it's
in
not hearsay because of why?
introducing it for the purpose of providing that there was law enforcement involvement here. That's the purpose to which it was submitted to the declaration, included in the declaration in paragraph 13 and 17. There's nothing being offered as far as any police officers, conclusions, statements, anything like that.
So why is it being presented and why isn't it duplicative?
Your Honor, my tendency of practice is that it's helpful to provide this documentation to the court, and for the court to be able to see it. But again, it was just providing the documentation for the court of this did happen, and we want the court to be aware of that.
Okay. So with respect to G and I, the court does find that those documents are hearsay documents. They're out-of-court statements by a declarant that is not present to testify about them, that contain hearsay statements, hearsay within hearsay statements. Because of that, the court is going to sustain the objection. So exhibits G and I referenced in the record index 25 and 27 are excluded.
Okay, the next one would be Exhibit H, which is index number 26. That one again is the text messages between the child and Crystal. And that one, you already sustained the objection, I believe, and that was the objection as to paragraph 15, where they direct quoted the information that the child allegedly was told by my client. So objection as to hearsay within hearsay.
Ms. Hackman?
Your Honor, I would make the same argument as I previously did, but recognizing that the court already sustained the objection as to the statement in the declaration, I don't expect that the court would receive this into evidence, and so I'm not going to repeat that same argument as to Exhibit H.
For the same reasons as before, the objection is sustained. Exhibit H 26 is excluded.
Okay, and then the last objection, I believe, that I have is on the supplemental declaration of Crystal Cole that appears at index number 37 in paragraph 4 on page 2, the statements that the child allegedly made to Crystal about what happened with the incident on June 20th, 2026. I would object to those statements.
So paragraph 4.
Correct.
Which goes on for 2/3 of a page.
Yep, at the top of page 2.
And so your objection is
Any statement that the child would have made about allegedly how she got that bruise.
okay. So it would have been starting with the word but in the second line.
Correct.
And ending with
She eventually told me. Correct. Yep.
Starting with the but eventually and ending with the period after bagel. The
Correct.
rest of that sentence.
Correct.
All right. Ms. Hackman.
Thank you, Your Honor. My position on this would again be that this is something that was relayed to Crystal, and she being offered for the effect on her, her intent in seeking this motion, the fact that she needed to take steps to protect the child here, which is a non-hearsay purpose.
So what it's being offered is to establish domestic violence for purposes of the best interest factors, right?
Mr.
That Mr. Cole caused or engaged in domestic violence against the child.
It is being offered for that, which is certainly relevant. I understand relevant information doesn't mean it's admissible, Your Honor. Mr. Cole is also here to be cross-examined on it and will be subject to questions about that incident.
All right. Court's to sustain the hearsay objection. So that portion is going to be stricken from the word "but" in the second line of paragraph 4, page 2 of the supplemental declaration through the end of that sentence ending with "bagel period." That portion will be stricken and not considered as evidence by me. Any other objections, Ms. Leeson?
No, Your Honor, I don't object to the remainder of the exhibits coming in, including the ones that were submitted as part of the supplemental declaration. I would note, I don't know, I think Ms. Cole might have been disconnected too. I don't see her on here anymore.
Well, there's a person connecting with the moniker iPhone. They're in the waiting room and I just added them. So we'll see if that's Ms. Cole.
Okay, perfect.
That appears to be Ms. Cole. So we'll get you renamed. All right. And I'm sorry, we kind of got disconnected there. Ms. Leeson, any other objections?
No, Your Honor, thank you.
Ms. Hackman, any objections?
No, Your Honor, thank you.
All right. So the remainder of the declarations and exhibits which the court has not ruled on were offered and admitted without objection. So those will be received. And Ms. Leeson, if you can prepare a written order summarizing the court's rulings on your objections, so that's in the record in writing as well, I would appreciate it. And send that proposal over to Ms. Hackman, and when the two of you agree, send it over to me for consideration, and I will sign that order, just documenting in the Odyssey record, not just in the oral record, how I ruled on your objections and what was stricken and what is not stricken.
I will do that.
Thank you. Ms. Hackman, and it's your motion, so you get the first opportunity to go. Do you have any opening statement?
I do not, Your Honor.
Ms. Leeson, do you have any opening statement?
I would waive.
All right. Ms. Hackman, you can go ahead and call your first witness.
Okay, I would call Mr. Adam Cole to the stand, Your Honor.
All right. Mr. Cole, I need you to, I'm going to add a pin here, so hold on a second here. I need you to raise your right hand so I can see it, sir. Sir, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can lower your hand and then please state and spell your full name for me.
My name is Adam Cole, ADAMCOLE.
Go ahead, Ms. Hackman.
Thank you. Mr. Cole, you and Crystal have been married since June 2023, is that correct?
Yeah,
Okay, you share a daughter.
yeah,
Okay, are her initials WRC?
yeah.
How old is she?
8,
You said 8 years old, correct?
yeah,
Okay. You would agree that you and Crystal have been separated since November 2025, correct?
yeah,
Okay. Crystal began to rent her own townhome at that point, correct?
yeah,
Okay. And the expectation was that Crystal would have her townhome and you would stay at the marital residence, is that correct?
yeah,
And since Crystal moved out, she has not shown up unexpectedly at the marital home at any point, right?
I can't say.
You'd agree neither one of you should be showing up unexpectedly to the other person's residence, correct?
Correct.
Okay. You'd agree you didn't want to separate from Crystal, is that right?
Correct.
Okay, and you still don't want to be separated, is that fair to say?
Correct.
Okay. You'd like to reconcile with Crystal, right?
Correct.
Okay. You stated in your declaration that I believe we could still work it out with time and counseling. Is that right?
Correct.
Okay. Crystal has indicated to you that she is not interested in reconciling, correct?
Correct.
Okay. And you continue to believe that you and Crystal could reconcile even after Crystal filed her present motion indicating she feels harassed by you?
Can you repeat the question?
Okay. You filed your declaration after you saw, after you reviewed Crystal's declaration, correct?
Yeah,
Okay. And after you reviewed Crystal's declaration, you still continued to believe that you could reconcile?
I do.
Okay. Crystal has indicated to you that she only wishes to communicate with you if it involves your daughter, right?
Mostly.
Okay. She has communicated that with you several times, right?
Yes.
Okay. In your supplemental declaration at paragraph 6, you acknowledged that you spanked your daughter, correct?
Mm-hmm.
Was that a yes?
Yes.
Yeah.
Okay.
So Mr. Cole, and Miss Cole, I know that you're listening. It's important when you're answering questions to use words like yes or no and not nonverbal things like mm-hms and uh-huhs. And it's because if a transcript is ever made, it's difficult to determine whether mm-hmm is a yes or a no when they try to put your testimony to words on paper. And so if either of you do that, I'm sitting here watching you testify from your body language and the response and tone. I can tell what those things mean. But if another court ever had to review the matter, it would be difficult for them to determine whether your answer is a yes or a no or some other response if you use those sort of nonverbal, informal responses. So it's just important to make sure that you use verbal responses with words that the record can accurately record. Okay?
Okay.
All right. Thank you. Go ahead, Ms. Hackman.
Thank you, Your Honor. Just, I want to be sure the record is clear. So your declaration at paragraph 8, you stated I did spank her, and you agree with that statement. You did spank your daughter, right?
Yes.
Okay. You'd agree as a parent, you are entitled to use some discipline, right?
Yes.
Okay. And Crystal is likewise entitled to use some discipline with your daughter?
Yes.
Okay. You understand it has to be a reasonable amount of discipline?
Yeah.
Okay. Was that a yes? I just wanted to make sure I heard.
Yes.
Okay. You stated in your supplemental declaration that you don't see a handprint in the photo Crystal submitted. Is that right?
Right.
Okay. My paralegal is on here, Your Honor. I'd have her pull up Exhibit O, which was renumbered for this hearing, but it was included as Exhibit A to the supplemental declaration, and these copies were provided to Miss Leeson as well.
So, Ms. Hackman, you're saying that these are not what's in the record, but rather renumbered? I want to make sure.
Yeah, just the ones that were provided with the supplemental declaration so that we didn't start with Exhibit A to N and then have new Exhibit A to H. So for the purpose of keeping the record clean, we had provided with Miss Leeson with Exhibit A now became Exhibit O, Exhibit B became Exhibit P, vice versa. I can certainly file them following this hearing or handle this in a different way. I just didn't want to have too many different numbers floating around here.
Okay, so here's what I'm going to tell you. If you're referring to exhibits that I've already received and they're in the record, I want you to reference them by their record index number. So if you're talking about Exhibit A to the supplemental declaration, which was record index 38, say it's record index 38, and that avoids the problem.
Okay, I will do that, Your Honor. Thank you.
All right. So you have permission to share a screen with respect to exhibits that have been received.
Okay. You'd agree in this photo, you can see there are 3 bruises there that look like the imprint of a hand, specifically being 3 fingers. Is that right?
I can't say it looks like a hand.
Okay, okay. You don't see three marks there that look like they
I
could.
see, I see 3 marks, but it doesn't look like a hand to me. And I also talked to Wesleyan. I, str- huh? I talked to Wesleyan. It was on the left side, not the right side. And it wasn't over a bagel.
So you don't agree that those 3 marks right there that show look to be 3 finger marks.
No, I don't.
Okay. And the angle of those marks and the angle of your daughter, with where they're at would be such that you would be holding one side and restraining her and then using force to spank her on that thigh there, right?
No,
Okay. Okay. You'd agree if you agreed in your declaration, these happened around breakfast time.
no,
Ms. Hackman, is there a reason to continue sharing the screen? Thank you.
Thank you. Um, so in your paragraph at declaration, supplemental declaration at paragraph 8, you described after your daughter was done eating, you were cleaning up the kitchen, asked to finish getting herself ready, get off her iPad, and after several warnings, you did spank her. That was in the morning time period, correct?
yeah, yes, in the morning.
Okay. Okay.
About 9.
About 9 a.m. So
Yeah.
that would be around breakfast time approximately.
Yeah.
Okay. And just to keep the record here clean, Adam, I'd appreciate if I can finish my questions and you can go ahead and answer them, okay?
Okay.
Okay. So you agreed it was about 9 a.m. or so?
Mhm.
Okay. So from 9 a.m. to 2 p.m., it's quite a few hours for those marks still to be showing, right?
Yeah.
Okay. But your position is that that spot is not where you spanked your daughter.
Right.
Okay. And your position would be that those marks came from innocent childhood play.
Yes.
Okay. Innocent childhood play would be someone hitting your daughter hard enough to leave marks 5 hours later.
No.
Okay. After that incident, law enforcement contacted you about it, right?
No.
Have you contacted law enforcement?
Yes.
Did you participate in an interview with law enforcement?
No. I contacted CPS.
Okay. Did you participate in any interview with CPS?
No.
Have they requested that from you?
No.
You would agree getting to the truth of how your daughter got those bruises ultimately protects her safety, right?
Right. Yeah.
Okay. Okay. You stated in your declaration, I understand my messages and actions have made Crystal uncomfortable in the past, and I have worked to correct that behavior. Is that an accurate statement?
Yes.
Okay. You acknowledge in your declaration that when you pepper Crystal with questions, I understand now that this is viewed as inappropriate and I will stop. Is that correct?
Yeah.
Okay. And you also state that several incidents alluded to by Crystal happened before her attorney sent you a cease and desist letter. Is that right?
Yes.
Okay. That letter was sent to you through your attorney a couple months back, right?
Right.
Okay. Um, After Crystal filed this present motion, you threw her clothes into the garage, right?
I put them on top of the bed frame that was in there, yes.
Okay. As part of that, you smashed some picture frames, right?
Yep, yes.
Okay. You tore up some photos, ripped them in half.
Yeah, she didn't want them anymore.
You ripped up one of Crystal's shirts, is that correct?
Yep,
Okay. You ripped Crystal's wedding dress in the middle, correct?
yeah,
Okay. And your testimony is that you did not intentionally do any of that.
yeah,
Okay. Uh, and your position is that you didn't haphazardly just toss her belongings onto the floor. Is that right?
yes.
Okay. I am going to pull up um, index number 40, which was marked as Exhibit C to the supplemental declaration. Um, may I screen share, Your Honor?
Yes.
Okay. Um, this does not, in your opinion, Mr. Cole, show items that were thrown around haphazardly.
No,
Okay. Ms. Smith, can you go to the next page, please? Okay, and you don't believe that reflects items being thrown haphazardly?
no,
Okay. And that doesn't show items that were thrown haphazardly?
no,
Okay.
no. They had
Um,
a spot.
okay. You can stop sharing the screen, please. You agree you gave your daughter a bag with your wedding ring, and a picture of you and Crystal in it after she filed this motion, correct?
Yep,
Was that a yes? I'm sorry.
yes,
Okay. And the picture in there, the picture of you and Crystal was torn in half, right?
no,
You told Crystal following this motion, message her, I'll give you sex, I'll give you intimacy, I'll give you emotional support and empathy. I put up with it for 9 years. I deserve one day. Is that right?
no,
Did you say no? I'm sorry.
yeah.
Okay.
I don't remember that.
Okay. I will pull up exhibit B to the supplemental declaration, which is reflected at index number 39. May we screen share, Your Honor?
Yes.
And Ms. Smith, I'll have you go to page 7, please. I have the incorrect page number noted, Your Honor, but you'd agree if that's within the messages that are between you and Crystal that are provided as Exhibit B, that you said that, correct?
Correct.
Okay. Okay. It's actually Ms. Smith, if I can go back, it's page 8. Do you see that message in the latter half of the page there? Dated June 21, June 21.
Yep, back in June. Okay.
Okay, and that was after this motion was filed?
It's possible.
Okay, you understand Crystal filed a motion with the court on June 9th?
Okay, yeah.
Okay, and then you sent this message to her on June 21st?
Yeah. If I received her notion by then, I don't remember.
Okay, and you have continued to pepper Crystal with questions, that's fair to say, right?
Yeah.
Okay, there are times you may text Crystal 10, 15, 20 times in a row?
Mm, no, not that many times.
Have you been to Hobby Lobby recently in Fargo?
Yeah,
Okay, when was that?
yesterday.
Okay. Did you see anyone in particular there?
No, Crystal and her mom and my daughter.
Okay. So yesterday you just happened to run into Crystal and your daughter in Hobby Lobby in Fargo?
Yep.
Okay. Do you go to Hobby Lobby regularly?
No, not regularly, but I was doing the strip.
Okay.
But
Okay.
I have quite a few times, yes.
Okay. So out of all places in Fargo, when you live in Valley City, you just happen to run into Crystal and your daughter at Hobby Lobby at the exact same time?
Yep,
Okay. And that was just a coincidence yesterday?
yep.
Okay. And you would testify, you'd agree, you would say you didn't track them there. Is that right?
Right.
Okay. And your testimony is that you did not track them when you showed up at the pool in Valley City?
Yep,
Okay. So you just happened to run into them there coincidentally?
yep.
Okay. So going back to your declaration, when you state at paragraph 7, I have worked to correct that behavior. What exactly are the specific corrections you have made?
I leave her alone. I
Okay.
still want communication.
Okay. The text messages reflected in Exhibit P are leaving Crystal alone.
Yes, from when it started to now.
Um, and you stated in your declaration, um, I understand now this is viewed as inappropriate and will stop. What did you mean when you said you would stop?
I don't know.
Okay, you agree it looks like this behavior has largely continued, right?
From the beginning to now, I see a downhill trend.
A downhill trend, what do you mean?
It's it's getting less and less every day.
I don't understand. Are you referring to your mental health? What's getting less and less?
The trying to talk to Crystal, trying to understand the what I've been accused of harassing, um, going from being married to 9 years. There was a lot of unfiltered talk we had in those 9 years of being able to express your feelings and speak the matter clearly to now it's more so a lot different, um, to where it has to be almost verbally correct to where
I'm gonna cut you off, Adam, here. You understand you and Crystal are separated, right?
yeah,
Okay, with
um,
that, there's going to be a change in communication. You understand that, right?
correct.
Okay, okay. You'd
But there
agree,
was there
I,
was
I,
no okay. There
I don't
was
have a
no
question. You already answered it. Thank you. You'd agree generally it's not appropriate to start a group message with an 8-year-old about an ongoing divorce, right?
correct.
Okay.
And I don't believe I used the word divorce in
Okay.
any of those statements.
But you did start a group message.
Mr. Cole, stop. I want you to listen to the question that's being asked and answer only the question that's being asked. Okay, so if there's not a question posed, you need not to speak.
Okay.
You
Okay.
need to focus and just listen to the question, think about it, and then answer the question only, okay?
Okay.
All right, thank you. Go ahead and ask your question again, Ms. Hackman.
Okay, you did agree that it's not appropriate to start a group message with an 8-year-old about an ongoing divorce, right?
Yes.
Okay. You started a group message with your daughter and Crystal about wanting to be a family with Crystal, correct?
Yes.
Okay. In a message that contained your daughter, you stated that your daughter is on my team, Crystal. Is that right?
Yes.
Okay. And you have shared information about the divorce with your daughter, right?
Yes.
Okay. Has that included information about the divorce papers?
Yes.
Okay. Have you relayed that Crystal cheated on you?
No.
And even if that was true, you would agree that an 8-year-old doesn't need to be involved in issues like cheating if that did happen, right?
I'd
Yeah.
object as to relevancy. He already testified he didn't, so it's not a fact.
Sustained. Move on, move along.
Okay. So you'd agree you've done some things here that could be considered not appropriate, correct?
Yes.
Okay. Crystal has asked you to stop speaking with your daughter about the divorce. Is that right?
Yes.
Okay. In response, you stated your daughter deserves the truth as much as me. Is that right?
Yes.
Okay. So you'd agree that statement doesn't reflect a denial that you've spoken with your daughter about this. Is that right?
Yes.
Okay. In February of this year, you wanted to take your daughter to a hockey tournament on what you and Crystal had agreed upon as Crystal's parenting time, correct?
Don't remember.
Okay, we will look at Exhibit A to the original declaration of Miss Cole, which is found at index number 21, Your Honor. May we screen share?
Yes.
Okay, and specifically, we'll be looking at the end of page 23 and the beginning of page 24. Ms. Smith, I'll have you scroll a bit here, please. Okay. This is a conversation about a hockey game in February, right?
Mm-hmm. Yes.
And you had wanted to take your daughter on to this game?
Yes.
Okay. You stated to Crystal, I am aware of the list of medications you intake.
Yes.
You have not raised any such issue now, correct?
Yes.
Okay. Ms. Smith, you can stop screen sharing. You're not making any allegations that Crystal is mentally unfit or taking medication that impairs her parenting time, right?
Right.
Okay. You'd agree Crystal has asked you not to show up where she is or where her and your daughter are during her parenting time, correct?
Yes.
Okay. In May, you showed up at a hotel where Crystal and Westlyn were swimming, or your daughter were swimming. I'm sorry, Your Honor.
Yes.
Um, in April 2026, you left Crystal flowers at her car, right?
Yes.
Okay. In May 2026, you showed up with blizzards at Crystal's home. Is that right?
Yes.
Okay. You've dropped off your daughter at Crystal's home at 5:43 a.m. without prior arrangements for that, correct?
Yes.
Okay. And yesterday you just happened to be at Hobby Lobby in Fargo, an hour away at the same time as Crystal and your daughter?
Yes.
Okay. You're aware that your daughter's tablet is under Crystal's mother's Apple account, right?
Yes.
Okay. And because of that, you're aware Crystal's messages also sync to your daughter's iPad, is that right?
Yes.
Okay. And you've acknowledged that your daughter reads Crystal messages on the iPad, right?
Yes.
Okay. And you've read through Crystal and her mother's messages through your daughter's tablet too, right?
Your Honor, I'm going to object to that. That's outside of my client's declaration. This is cross-examination and going beyond that.
Ms. Hackman, can you point to a specific paragraph or statement in the declaration to which you're cross-examining him on?
I can move on, Your Honor. I'll withdraw the question.
All right, just for the record, it's sustained.
Okay. I'll turn to the best interest factors in your declaration, Mr. Cole. Throughout the best interest factors, you argue they should result in equal residential responsibility, correct?
Yes.
Okay. You'd agree there's nothing that renders Crystal incapable of parenting your daughter?
Yes.
Okay. You'd agree Crystal's a good parent?
Yes.
Okay. And you understand the court will ultimately look at what's in Westland's best interest?
Yes.
Okay. You'd agree your daughter loves Crystal?
Yes.
Okay. And Crystal loves your daughter?
Yes.
They show each other appropriate affection?
Yes.
Okay. And you'd agree that Crystal can provide that moving forward, right?
Yes.
Okay. You'd agree reconciliation with Crystal have resulted in sharing adult information with your daughter?
Yes.
Okay. And you'd agree providing appropriate guidance to your daughter includes handling adult issues appropriately, correct?
Yes.
Okay. You'd agree Crystal can provide your daughter with adequate food, clothing, shelter, medical care, and a safe environment?
Yes.
Okay. You agreed in your declaration that Crystal historically handled most of your daughter's medical appointments?
Yes.
Okay. And Crystal, to your understanding, her work schedule has that flexibility to manage those appointments moving forward?
Yes.
So you don't have concerns with Crystal under this factor, correct?
Correct.
Okay. And you'd agree that part of providing a safe environment for your daughter is ensuring that she feels emotionally safe?
Yes.
Okay. You'd agree it can affect your child's emotional stability and sufficiency to share adult issues with her?
Yes.
Okay. You agree that Crystal has the ability to meet your daughter's developmental needs?
Yes.
Okay. You and Crystal both reside in Valley City?
Yes.
Okay. You have not raised any issues regarding Crystal's home environment, right?
Yes.
Okay. Crystal's mother attends activities for your daughter, right?
Yes.
Okay. And she has a positive relationship with Crystal's family. Is that fair to say?
Yeah.
Okay. And you'd agree part of maintaining a stable home environment is that you have to be in the right mental space to maintain that stability, correct?
Yes.
Okay. You did acknowledge earlier that you started that group message with your daughter and Crystal. Is that right?
Yes.
Okay. And you have shared your feelings about your divorce with your daughter?
Yes.
Okay. In those group messages with Westland, or I'm sorry, Your Honor, with your daughter that we looked at earlier, you stated, "Don't be afraid, Dad will always support you." Is that right?
Yes.
Okay. You'd agree those conversations should be handled between you and Crystal and not with your daughter involved, right?
No.
Okay. You don't see any issue with those messages that you were sending to with
Not,
Westland in there, with your daughter in there?
no, not tell, no.
Okay. Something you raise issue with in your declaration is Crystal's recordings of your daughter, right?
Right. Yes.
Okay. Uh, More recently, you've been asking your daughter to make statements so you can record those, right?
No.
I'm going to object. It's outside of the scope of his declarations, either one of them.
Sustained.
You have called Crystal with your daughter during your parenting time, right?
Yes. Yeah.
And you've had your daughter invite Crystal on activities with both of you since your separation, right?
Yes.
Okay. Uh, and then you blame it on Crystal for the family not doing activities together, all three of you. Is that right?
No.
Okay. You have questioned Crystal's willingness to facilitate a relationship between you and your daughter. Is that right?
What do you mean?
Okay. In your declaration, you stated that I have started to see things that make me question Crystal's continued willingness to facilitate a relationship between myself and our daughter. Is that right?
You're asking me if I've seen her willingness to participate?
Well, I'm asking you about what you wrote in your declaration. I was just reading from your declaration. So do you have concerns about Crystal and her ability to facilitate a relationship between you and your daughter?
No.
Okay, so no concerns there, uh, as related to the willingness and ability to facilitate a relationship.
Correct.
Okay. You would agree it's appropriate to share age-appropriate information with your daughter?
Yes.
You'd agree that you signed Crystal's signature on your 2025 tax return, is that right?
Yes.
Okay. You stated you did that because you were afraid that Crystal hated you, is that right?
Yes.
Okay.
Uh,
So you acknowledge that was done without Crystal's permission, right?
Yes.
Okay. And you do not raise any issues with Crystal's moral fitness, correct?
I didn't raise any what?
You haven't raised any issues with Crystal's moral fitness, right?
Right.
Okay. You believe you do not have any present mental health concerns. Is that fair to say?
Yes.
Okay. You would agree you're struggling with your separation from Crystal?
Yes.
Okay. You may have good days, you may have bad days as it relates to that separation. Is that fair to say?
Yes.
Okay. Would it be fair to say the bad days have been when you've shared information with your daughter?
No.
So on your good days, still you're sharing that information.
No.
You would agree, your daughter has started to become more emotional in recent months. Is that fair to say?
Again, I'm going to object. It's outside the scope of his declaration.
Ms. Hackman, can you tie
Uh,
it back to a paragraph or statement?
Yes, there was a statement in the declaration, Your Honor, as far as the child participating in counseling. Um, I am going to try and point to it here. But in any event, there was a statement about the child participating in counseling, and that being appropriate for her. And so just talking more about that therapy that the child is receiving and the counseling. That's in paragraph 26. related to
Overrule.
factor D.
Court will overrule the objection, but keep it narrowly tailored to something in the declaration, please.
Thank you, Your Honor. You stated, Crystal mentioned in her declaration that your daughter would be attending counseling. You fully supported that and have paid for counseling services. Is that right?
Yep. Yes.
Yeah, that was a yes. Okay. But when you were messaging Crystal about that, you said it was essentially Crystal's fault that Westland needed to be in counseling. Is that right?
Yes.
Okay. You'd agree it's a good thing for a parent to ensure their mental health needs are properly addressed, right?
Yes.
Okay. And you do not raise any issues with Crystal's mental or physical health, correct?
No.
Okay. You agree there have been no changes to your daughter's home, school, and community records as a result of your separation, other than she has 2 homes now. Is that fair to say?
Yes.
Okay. You and Crystal discussed a nanny for your daughter's summer care, right?
No.
She did inform you of the nanny prior to hiring her, right?
Yes. Yes.
Okay, she told you how much the nanny was going to cost, is that right?
Yep.
Okay, and you didn't raise any issue with that, right?
No.
Okay.
Uh,
You'd agree Westland is too young to make a decision about residential responsibility and parenting time, right?
no.
Okay. At 8 years old, you think that your daughter should be able to participate in these proceedings?
No.
Okay, so which one is it? Is she too young, or is she able to participate in these proceedings?
She should be, I believe that she should be able to see both of us equally. And I know that's what she wants.
And I will move to strike that last portion of that response. It's not responsive, Your Honor.
Sustained. So, Mr. Cole, the question is whether or not your daughter should be able to participate and tell me what she wants, not what she told you what she wants, but whether or not you think she's old enough to participate and express her preference. Do you understand the question?
Yeah.
So why don't you answer that question?
I'll say no then. Yep.
That she's not old enough to participate.
Right.
Okay. Go ahead, Ms. Hackman.
Thank you. As to domestic violence, you state that's inapplicable, correct?
Correct.
Okay. There were several times during your marriage with Crystal where you punched walls or a bed frame or yourself in the head. Is that right?
No. There was 3.
It was what?
3.
3? What do you mean?
It was 3 times. She said I did it 3 times.
Okay. Do you agree with that?
Yes.
Okay. Okay. And you'd agree your daughter shouldn't be exposed to that.
Correct.
You'd agree it's concerning that your daughter had a bruise on her thigh that you could see 5 hours after it happened, correct?
Yes.
Okay. Um, do you disagree with Crystal's characterization of you dragging your daughter into a residence?
Yes.
Okay. So you disagree with that characterization of the incident, but ultimately you do agree that it happened, that you picked your daughter up and carried her inside after the separation, correct?
Yes.
Okay. You're not concerned about anyone that is around your daughter during Crystal's parenting time, correct?
Correct.
Okay. You agree Crystal has not harmed your daughter?
Yes.
Okay. So you stated earlier in your declaration that Crystal has also spanked your daughter, but you do agree that Crystal has never caused harm to her, right?
Right.
Okay. You're willing to use our family wizard moving forward, correct?
Yes.
Okay. And you acknowledge in your declaration that communication should be limited to your daughter. Is that right?
Yes.
Okay. So you believe it's appropriate for the court to order you to use our family wizard,
Yeah.
right? Okay.
Yeah.
With that, you want the court to impose a requirement that messages need to be responded to within 8 hours?
So what do you mean? If Crystal texts me, I have to respond within 8 hours?
So your declaration states, I'm willing to utilize our family wizard going forward for communication with Crystal and agree that communication should be limited to issues involving our daughter. I would ask, however, that a requirement be made that messages should be responded to by each party within 8 hours. Is
Yeah.
that your request?
Yes.
Okay, so your proposal is if you message Crystal at midnight, let's say she needs to respond to it by 8 a.m.
No.
Okay. So you'd agree this requirement that you would have to respond within 8 hours isn't necessarily workable or realistic, correct?
Correct.
Okay. You are requesting that if the court orders you to get a parental capacity evaluation, that the court also orders Crystal to get one as well?
Yes.
Okay. And that's even though you have not raised any mental health concerns for Crystal?
Correct.
Okay. And you're not raising issue with Crystal's ability to provide Westland for your daughter at all, right?
Right.
Okay.
Correct.
And you claim that you can't afford to pay for that. Is that right?
No.
Um, you stated in your direct declaration, I do not see any need for parental capacity evaluation, nor do I have the ability to pay for the same. Is that right?
Correct.
Okay, so can you pay for the costs of a parental capacity evaluation or can you not pay for the costs of it?
I can pay for it, yeah.
Okay,
For myself, yeah.
okay. Turning to your financial declaration here briefly, you're currently laid off from John Deere, right?
Yes.
Okay, that's a pretty usual standard of practice in the summer months for John Deere, right?
Yes.
Okay, what months are you typically without work?
Usually starts March till about July here. You know,
Okay.
sometimes we go into August, but it's every year and it fluctuates.
Okay, when do you expect to go back to work this year?
The 20th, so in a week.
Okay, so in about 5 days here, you'll be returning to work at John Deere?
Yes.
Okay. During this period where you're laid off from John Deere, are you eligible for unemployment benefits?
Yes.
Do you receive unemployment benefits?
Yes.
How much do you receive?
681, I think it is.
$681 per month, per week?
Per week.
Per week, okay. Okay. So when you resume work on the 20th here in 5 days, your ordinary income will resume at that point, right?
Mm-hmm.
What's that a yes?
Yes.
Okay. And based on your pay stubs, you make 36.48 per hour. Is that right?
Yes.
Okay. How many hours per week do you typically work?
40.
40? Do you receive overtime?
No, not normally.
Mr. Cole, you'd agree generally a child benefits from having two mentally healthy parents, right?
Yes.
Okay. You'd agree of the focus in this case is on your daughter.
Yes.
Okay. And you'd agree that your daughter benefits from having two mentally healthy parents.
Yes.
Okay. And the court ensuring that your daughter is safe in either yours or Crystal's care, that would make sense, right?
Yes.
Okay. I have nothing further, Your Honor.
All right, Ms. Leeson, the court does give, although Rule 8.2 is silent on the matter and has a rather unique approach to evidence, I do allow the declarant's attorney to redirect, and I'm going to allow you, Ms. Hackman, to redirect your client as well. So, Ms. Leeson, do you have any redirect questions for Mr. Cole? And if
I
you would
do not.
limit, okay. All right, with that, thank you, Mr. Cole. Ms. Hackman, any other witnesses, evidence, or testimony? I don't believe so, but
No, Your Honor.
all right, Ms. Leeson.
Thank you. I'd call Crystal Cole.
Ms. Cole, I need you to give me just a second here. Ms. Cole, I need you to raise your right hand for me. Ma'am, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Below your hand, please state and spell your full name for the record.
Crystal Cole, Krystalcole.
Go ahead, Ms. Leeson.
Thank you. Is it okay if I call you Crystal?
Yes.
Crystal, you and Adam are married, correct?
Correct.
Okay, and married in June of 2023?
Correct.
Okay, but you were together in a relationship prior to the time of your marriage, correct?
Correct.
And in fact, your daughter was born prior to your marriage, is that correct?
Correct.
Okay, and how long had you been in a relationship with Adam prior to your separation?
9 years.
9 years. And true that you separated in November of 2025?
Correct.
Okay, was that a decision that was a mutual decision for the two of you to separate, or a decision that you came to?
Decision that I came to for my safety.
And at that time, you moved out of the marital home, is that fair?
Correct.
And have moved into a rental, or did you buy?
Rental.
And that rental is located still in Valley City, is that accurate?
Correct.
And Adam continues to live in the marital home, which is also located in Valley City?
Correct.
Okay, how far apart are your residences?
I don't know exact, but it's across town. So I'm on the south, he's on the
Valley
north.
City. Sorry. Valley City is not that large. Driving time, 5-10 minutes?
Correct.
Okay. Are you currently employed, ma'am?
Yes.
Where are you employed at?
Essentia Health in Jamestown.
And what do you do there?
I am the supervisor for the lab at Jamestown, Lisbon, and Valley City.
So you work out of Jamestown, commute every day?
Correct.
What are your typical work hours?
8:30 to 5:30.
Okay. And that's about a 45-minute commute then for you?
35 minutes.
So typically leave the house around 8 a.m. and you're home by 5:30, 6 o'clock. Is that accurate?
More so 5:30, 5:35, I'm home.
Okay. I thought you said you work till 5 or 5:30.
So my clock out time is when I get to my house.
Okay, gotcha. And do you work Monday through Friday?
Correct.
No weekend time?
Correct. No weekends.
Are you hourly or salaried at that position?
Hourly.
How much are you paid per hour?
Off the top of my head, I'm not sure on the exact 38, 78 or somewhere around the line.
Okay. And looking at your financial declaration and the exhibit that you had attached, Is it fair to say there's a little bit of differential in pay, that sort of thing? Or am I reading your pay stub incorrectly?
Differential between paycheck to paycheck.
No, for instance, there's a description on your paycheck. It says callback 1.5 times and then the rate at $59.85 per hour.
Yep. So I am able to receive callback and overtime with this position.
Okay. And looking at that pay stub, is it fair to say that your hourly rate is at $39.90?
That's more accurate then.
How many hours of overtime do you typically work in a pay period?
8 to 10, but it also fluctuates.
And you're paid every 2 weeks?
Correct.
So you have between 16 and 20 hours of overtime pay in a month on a 4-week basis?
Give or take. Yeah.
Okay. And that overtime rate is at $59.85. Is that accurate?
Off the top of my head, I'm not sure, but if that's what the pay stub says.
Do you provide medical insurance?
I do not.
Okay. Does Adam provide that?
He does.
So there's you don't provide insurance for yourself either, correct?
I have myself insured.
Okay, but he insures your daughter?
Correct.
Okay, so no out-of-pocket cost for you for that. Is that accurate?
Correct.
You have the one minor child with Adam. Is that accurate?
Correct.
And you don't have any other children that are not Adam's children?
Correct.
Okay. And your daughter's name is Weslyn, accurate?
Correct.
Okay. And she was born in 2017. Is that fair?
Correct.
Okay. What grade is Weslyn going to be in this next school year?
3rd.
And what school does she attend?
Jefferson Elementary.
And that's right there in Valley City?
Correct.
You don't have any plans to relocate from Valley City while this divorce is pending, do you?
No.
You separated from Adam, we established in November of 2025. Is that correct?
Correct.
Okay, what's the parenting schedule you've followed since that time?
Week on, week off.
And what day do you do exchanges, ma'am?
Most of the time it's Sunday evening or sometimes Monday morning.
And do you do those exchanges at each other's homes, or how do you logistically work that?
At each other's homes.
So if you're coming off your week, do you drop off with him or does he come pick up from you?
Usually I pick up and or drop off at his house.
Is that an arrangement that has worked? I didn't see that you've requested to make any changes to how we work transportation.
In the past, it has worked, yes.
Does Westland have her own phone?
Yes.
So,
Do you-
Miss Lisa, I'll have you refer to the child as either by initials or just call her the child, if you would, please.
I will. Sorry, it escaped my mind.
Thank you.
How long has she had her own phone?
The exact time, I'm not sure, but I would estimate a year.
So prior to your separation from Adam?
Correct.
Does she at times communicate with you using Adam's phone?
Yes.
Does she at times communicate with Adam using your phone?
No.
There, you were present on this Zoom hearing when questions were asked of Adam by your attorney, correct?
Correct.
Okay, and you heard those questions about involving your child unnecessarily in adult issues, correct?
Correct.
And you would agree that that would not be a proper thing for either one of you to involve her in your divorce action, correct?
Correct.
Do you think that also includes asking her questions about what does your dad tell you?
Yes.
And you acknowledge that you've submitted a recording that was accepted as exhibit F or E, I'm sorry, that you're asking her questions about what her dad tells her, correct?
Yes.
Okay. If it is important to maintain that child's autonomy, if you will, and not be involved, would you agree that that would be improper for you to continue to do that?
Yes.
So it's not just you're asking Adam to stop involving her. You acknowledge you need to stop involving her as well.
Yes.
Do you intend to continue recording conversations of your child to use as evidence?
Yes.
Okay, you don't think that's continuing to involve her in these proceedings?
Yes.
Yes, you don't think that's improper?
It is improper.
Thank you. You indicated in your declaration that there was an incident, I think it was back in maybe April, that you contacted law enforcement, correct? And made an allegation that Adam had been, I guess, forceful with forcing your daughter into the house, correct?
Correct.
And as a result of that report that you made, did you also make the report to Child Protective Services?
No.
Did law enforcement make that report to Child Protective Services?
Correct.
And you're aware that they investigated those allegations of us, correct?
Correct.
And you're aware that they made no findings of abuse, correct?
Correct.
You have outlined in your supplemental declaration an incident that you allege occurred on June 20th of 2026, correct?
Correct.
And on that day, you and Adam and your daughter spent the day together. Is that fair?
Most of the day, yes.
Okay, what time did you arrive together at this event in Valley City?
Around 10 a.m.
Okay. And then you said you decided to go swimming sometime around 2 o'clock. Is that fair?
1:30 p.m.-ish.
Okay. And it was at this time that you discovered the bruise that you then took a picture of and have submitted into evidence, correct?
Correct.
Following discovery of that bruise, also true that you and Adam then went to the pool together with your daughter.
Correct.
You did not at any time ask him about that bruise, did you?
Correct. I didn't.
And you did not at any time on that date, being so concerned about that bruise, contact law enforcement, did you?
No.
In fact, you waited nearly an entire week and contacted them on Friday, June 26th, correct?
Correct.
Okay. You indicated in your declaration, let me ask you this, between June 20th, when you noticed this bruise, and June 26th, when you elected to report this, did you at any time have a conversation with Adam about that?
No.
Never once thought to ask him, hey, this is a little concerning. What do you know about it?
No,
Could that be because you weren't all that concerned about it?
no,
You stated in your declaration that your daughter was to have a forensic investigation on July 2nd. Did you mean a forensic interview?
I don't know if they're interchangeable or not, but interview investigation.
Okay. And did she in fact have that interview?
Correct. Excuse me.
Correct?
Say that again. I didn't hear you.
Correct.
So the interview did happen. Let's see, that would be 13 days ago on July the 2nd, correct?
Correct.
Okay. Have you had further communication from Child Protective Services since you signed this declaration on June 30th?
Yes.
Was that just at the forensic interview?
No.
Okay. Are you aware that there's been no communication from them to Adam regarding that incident?
Correct, because I had to contact the BCPD today on where the report stands.
Okay. And you're aware that when Adam submitted his supplemental declaration last week on Thursday, he had already reached out to find out that information, correct?
I was unaware.
You didn't
Your
see
Honor.
that in his declaration?
I'm going to object. My client lacks personal knowledge of the communications that took place with the defendant, Your Honor.
That's why I'm asking if she knew if they had contacted him. She doesn't. That's fine.
I'll sustain the lack of personal knowledge objection. Go ahead.
So as we sit here today, there's been no finding of abuse from Adam to your daughter, correct? From CPS.
Correct.
Okay. Have you had further contact from any law enforcement officer with regard to that incident?
Just what I spoke today.
And that was calling to find out a status,
Correct.
but they've not contacted you and asked you to come in to do an interview.
Correct.
They've not contacted you and asked you to bring your daughter in to do an interview.
Correct.
And CPS has not contacted you to do an interview.
Correct.
You acknowledge, or would you acknowledge, that you also spank your daughter?
Yes.
And you would acknowledge that a spanking can be used as appropriate discipline, depending on the behaviors, correct?
Dependent. Yes.
Is it fair to say, Crystal, that your biggest issue here is the fact that Adam is having some difficulty, if you will, accepting the fact that your marriage is ending?
Yes.
Thank you. That's all the questions I have.
Ms. Hackman, I'm going to give you the same opportunity I gave Ms. Leeson. Is there any redirect that you have for Ms. Cole?
Briefly here, Your Honor. Ms. Cole, you testified that you've been doing the week on, week off schedule since November 2025. Is that right?
Correct.
Okay. Is this schedule continuing to work well for your daughter?
Yeah.
Okay. Do you have concerns about continuing with this schedule?
Yes.
Okay.
And
What,
no.
okay. What concerns do you have?
That her emotional well-being and that she does make it known sometimes that she does not want to go to her dad's house.
I'm going to object. That's hearsay, Your Honor.
Sustained.
Have you thought it would be appropriate, Crystal, to change the schedule without court order to do so?
No.
Okay. Those recordings, you were asked about one of them. When you did make any recordings, did you start those conversations with the purpose of making a recording for use in court?
No.
Okay. Did you tell your daughter you were recording her?
No.
Okay. So does she know those exist to your knowledge?
No.
Okay. As to the recent June 20th incident, are you aware of any finding whatsoever in that investigation?
As of today, there's nothing reported.
Okay. Okay. So there's been no finding of abuse at the present time, but likewise, the investigation hasn't been closed out. Is that fair to say?
Correct.
Okay. I have nothing further.
All right, thank you. Ms. Leeson, any other witnesses, evidence, or testimony?
No, Your Honor. Thank you.
Ms. Hackman, any closing argument?
Yes, Your Honor. So we're here on my client's motion for interim order. She's seeking a temporary order that provides for the temporary primary residential responsibility of the party's child based on the best interest of the child. She's requesting that child support be established, that the parties communicate solely through our family wizard and only involving the child, and that defendant undergo a parental capacity evaluation. The declarations that have been submitted along with the cross-examination do show that this is the appropriate arrangement during the pendency of this proceeding. There has been a deterioration here following the parties' separation. While the parties were able to maintain an equal schedule for the past several months, the present circumstances here have led to the concerns for the child. She's being exposed to adult information. She is returning home crying about things. She's become emotionally upset. She's been enrolled in therapy, which Mr. Cole acknowledged he blames my client for needing to take place. There's no allegations that Miss Cole is unable to parent the child. He agrees they're closely bonded. He agrees Miss Cole is able to provide appropriately for the child. He believes that equal residential responsibility should be maintained, showing that he does not take issue with any of Miss Cole's actions. My client is understandably concerned about his mental state, Mr. Cole's mental state, because of the concerning exhibits he has, concerning behaviors he has exhibited and continues to exhibit. He claimed in his declaration, I have been attending counseling and working through these emotions so that I can process them more appropriately. He claimed he has worked to correct this behavior. He understands that his behavior could be viewed as inappropriate. He has done absolutely nothing to stop his behavior. In fact, there's been an escalation of the behavior. Most troublingly of that was the bruise that Miss Cole noticed after she filed the motion. That is when a bruise appeared that is clearly in the shape of a handprint with 3 fingers was visible 3 hours later. Since filing the motion, that's when Mr. Cole left Miss Cole's belongings in her garage, smashed glass in photo frames, tore up her wedding dress and other clothes. There is an escalation of behavior here, and it ultimately is affecting the child. Mr. Cole, having read Miss Cole's declaration that she views his actions in showing up to her residence, the pool, to be stalking, and he still showed up at Hobby Lobby in Fargo yesterday. It is not convincing that that was a mere coincidence. There's no apparent end in sight to this behavior. The child's best interests are the priority. The court must look at the best interest factors. Ms. Cole is not requesting to limit parenting time. She's not requesting that that Mr. Cole never see the child again. She is requesting that certain terms are put in place to protect the child here, ensure that she's safe moving forward. and order on a temporary basis that she receive primary residential responsibility while Mr. Cole receives a parental capacity evaluation. In the circumstances, this is appropriate. We are requesting that we have the opportunity to provide child support calculations following this hearing. Mr. Cole does not dispute that the court should order all communication take place through our family wizard. Today, he did not persist in his request in his declaration that the other party must respond within 8 hours. So we're not asking that that term be awarded. Based on a review of the best interest factors, we do believe that this arrangement is in the best interest of the child here on a temporary basis. Thank you, Your Honor.
Ms. Hackman, how long do you think you'd need to prepare and submit
Child support
child
calculation,
support?
a week, Your Honor, should be sufficient.
All right. And you're not asking that I hold the record open for any other reason?
No, Your Honor.
All right. Ms. Leeson, any closing argument?
Thank you, Your Honor. I think it's fair to say that my client is struggling a little bit with the end of his marriage, right? That doesn't mean that he's a bad father or that any of the information that was presented is relevant to those best interest factors, Your Honor. These parties have been following a week on, week off parenting time schedule for the past 8 months. We are scheduled for trial in 4 months. Ms. Cole herself testified that this schedule is working well for the child. It's Ms. Cole that wants to make a change. That to me does not make any sense whatsoever. If the schedule works for the child and is in the child's best interest, especially considering that we are so very close to trial and there's a plethora more information I'm sure that will be submitted to Your Honor in support of each party's positions at trial, it doesn't make any sense to me to make a change. When we look at the best interest factors, my client has laid those out in his declaration, which has already been accepted by the court as his testimony. I think each of those best interest factors supports a finding that it's in the child's best interest on an interim basis to continue with the 50-50 week on, week off schedule. There's no reason to make any big changes for her or to upend her status quo. What I've heard today is not convincing to me, certainly. There is an allegation of abuse. It wasn't even concerning enough to Ms. Cole that she reported it to anybody until nearly a week later. She didn't even bring it to his attention to ask him, hey, what the heck happened here? That's contrary to just normal parenting behavior, right? There's been no finding of abuse from CPS, and it is the fact that she waited a week to report that is certainly not in line with what her previous actions have been. There was another incident that she thought was abusive that she immediately reported to police. It was investigated, found to not be abuse. So the fact that she would wait another week on an incident where she claims is so serious is a little bit concerning and should cause a little bit of pause to the court. In all, I think the best interest factors support that we should continue with the 50-50 schedule on an interim basis. My client denies that he needs to have a parental capacity evaluation. I'll leave that up to the court. He is agreeable to continuing or to using our family wizard. The 8-hour thing was really just a suggestion. It was sort of an absurd example of if you message at midnight, does she have to respond by 8 p.m. or 8 a.m.? But certainly there should be some parameters that we can't just leave messages unread and not responded to as well. And then child support, I don't have any problem with the suggestion that we submit child support calculations because neither one of us did that for the court today.
All right, thank you. Ms. Hackman, it's your motion, so you get the opportunity to provide rebuttal argument if you wish.
Your Honor, we do continue to request that the court award my client primary residential responsibility on a temporary basis here. There are concerns that show regarding the defendant's mental states. I don't think that can be seriously disputed. There's documentation showing that it's negatively affecting the child and that there just are some parameters that need to be in place to ensure that this child is protected moving forward. Even though it is only 4 months until trial, it's still, this child here needs to be protected.
So, Ms.
And
Hackman, if I were to simply enter an order prohibiting that, because right now there's no order that prohibits him from, for instance, dropping in, and by him I mean Adam Cole, dropping in at Miss Cole's residence with blizzards. If I were to simply impose an order, doesn't that provide sufficient protection for the child? Because right now it's not court ordered and therefore it's not enforceable if there's a violation. But if I enter an order, there's certainly the power to impose contempt sanctions for violations. Isn't that sufficient when things have been going fairly well for 8 months?
there is a possibility, Your Honor, that an order that imposes simply terms will be sufficient. That's assuming that the parties follow them. And then, like the court said, there are contempt powers that follow after that. But related to that, there are these documented instances that are causing concern related to the child. And our position is simply that while we conduct a full investigation and get that parental capacity evaluation done, best case scenario for Mr. Cole is this comes back and there's no issues flagged. It's all related to the divorce. It's nothing that's causing concern for the child. We all move on and have a path forward in this case, but the child needs to be protected from this. And so I don't believe that simply saying, you guys stay at your own residences, it's sufficient for the circumstances that are present here.
So if I impose a condition that says no use of corporal punishment by either parent, that wouldn't be sufficient to protect the child? Because your client testified that she also uses corporal punishment. And if this incident, the one that is currently under investigation, is related to corporal punishment, which I think is unquestioned by either party, if I simply enter an order prohibiting corporal punishment from being utilized by either parent, isn't that sufficient?
Your Honor, the hope is always certainly that the parties will follow an order that's issued by the court.
Okay. Anything else, Ms. Hackman?
No, Your Honor.
Ms. Leeson, how long do you think it'll take for you to prepare your order on the objections and child support? Do you agree with the week?
A week is sufficient on that, yes. And I can certainly try and get that order. Tatiana, are you around tomorrow if I circulate it to you tomorrow morning to review?
Yes.
Okay. We can get that circulated tomorrow and then to Your Honor to review tomorrow.
All right. So I am going to hold the record open and I will receive the parties' child support calculations. If the parties have a stipulation on calculations under both proposals, I guess that makes things easier. But if not, I'll independently calculate child support based on the parties' submissions. I'll give you a week from today's date to file those documents. If they're filed sooner, that's better. The 22nd of July to prepare those documents and get them filed with the court. Again, sooner is better. I've been working on a draft of an interim order, so it's the shell is there. I probably will have it out within a short period of time, a couple of days after I receive the documents that the parties intend to present regarding child support. So the sooner the better. And like I said, if it takes until the 22nd for me to get those child support calculations, I probably will have my written decision out